An apple a day keeps the doctor away, but a glass of OJ keeps the adversary at bay. Here's Oddjob. Hey, it's time for a glass of OJ. I'm Oddjob. So, we're back again talking about SolarWinds because something very interesting has happened. But I think it's part of a bigger story to do with CISOs, their role, and the way companies, regulators, and even CISOs themselves look at the role. So let's do a little bit of history here and get up to today's business, which is December 2020. SolarWinds, of course, discovered that their IT management software Orion suffered a breach in the supply chain, whereby attackers were able to install a backdoor that allowed them access into a lot of customers' environments, and were able to then breach those customers' environments, including many government agencies. And the impact of this, was echoed in Kaseya suffering a breach. Now, maybe not as similar to that, but still suffering a breach nonetheless in summer 2021. And with IT tools makers taking such hits to brand trust, with many organizations having to rethink third-party risk management, software bill of materials, and challenging their suppliers for audits, it has to make us think, rethink a lot of things. Fast forward then to 2022, when the former CISO of Uber was convicted of obstruction of a federal investigation by the FTC, as well as misprision of a felony. It put the whole role of CISO into the spotlight. I think it was one of the first times we saw a CISO being charged with a crime in connection with a breach. And it was not necessarily the breach itself that lands you in prison. It is your cover-up of a breach, or potentially you going rogue and starting to play fast and loose with the law, taking things into your own hands, not talking to general counsel. So it's very interesting to kind of see how the CISO is starting to arise in the spotlight of government enforcement of regulations and laws. But SolarWinds now is making headlines once again because the Security and Exchange Commission, just in June, at the end of June, sent Wells notices to some of the current and former executives as well as employees of SolarWinds after an investigation they did into the 2020 incident. And essentially, for those of you who don't know, not a lawyer, but from my research, a Wells notice essentially just says the SEC is considering recommending legal action to the Security Exchange Commission, the actual commission of people who would have to vote on it and approve action. These actions could be many things. It could be, telling you not to do it again, essentially offering a warning to you. It could be issuing fines against your company or you personally. It could be, saying you can't be an officer of a publicly traded company ever again or for a period of so many years. It could also result in the Department of Justice going after you and going to court to, prison sentence or whatever else is supported by the Security Exchange Act. And, this generally gives recipients 30 days to give a response or to meet with SEC investigators to discuss reasons for why such action is unwarranted, and why allegations made are simply false. It should be noted that not everyone who receives a notice gets prosecuted or even charged or, punished by the commission. But this is the first time, and this is why it's noteworthy. It's the first time a CISO has been the recipient of a notice. So what does it mean? Get breached and go to prison? Well, just like the Uber CISO going to prison doesn't necessarily mean you have anything to worry about unless you're involved in illegal activity. It does mean we need to start talking about the role of the CISO, because companies and regulators are starting to disagree on this. Many CISOs quip, much to their detriment and harm, not only theirs, but the rest of everyone who is a CISO or wants to become one, that they're hired to be a scapegoat, or they're hired to go to prison or be the fall guy. And if you're one of those people, you need to stop saying that, because you're actually harming the industry, you're harming the occupation and the practice that so many people dedicate a lot of their lives to. You're really actually causing them a lot of harm when you do that. CISOs are not the ones who take the fall. If you're a CISO and you're going to take the fall because there was a breach or misreport of risk, that's because you did something wrong. That's not because you were hired to be the fall guy. It's you putting yourself in that position or allowing your company to put you in that position. But many companies do relegate their CISO to merely being a back office role. It's just the cost of doing business. We got to have this person around to keep the regulators off our backs or customers off our backs. And, we don't want it getting in the way of making money. There are some companies like that. Totally ignoring that your CISO should be a weapon in your arsenal for making sure others don't swoop in and literally take your money out from under you. And it's not just ransomware, the business email compromise, insider threat, cyber espionage. There's all kinds of threats to an organization that the CISO helps to mitigate and manage. And regulators see the CISO in a little bit of a different light. They see them as a role in the organization that should be speaking up and reporting issues to the most high stakeholders. We're talking the CEO and board, and also stakeholders themselves, the stockholders. And they're supposed to lay out the state of security across the company, help them understand risks, gaps, and threats, and offer plans to essentially take care of those gaps and threats. But now we're starting to see regulators really lay more burden and put more of a spotlight on CISO to take these types of actions to measure risk, report it properly, raise their voice when needed. And the real concern for me is that many companies aren't ready for that. They've not positioned their CISO in the organization to live that reality. When you have so many times I've seen and heard that CISOs are buried under the CTO, who's buried under the CIO, who's buried under the CFO, who reports to the CEO. So now you're at the CEO, then CFO, CTO, CIO, and now you're N minus 4. You're kind of low there in the organization, and it's really hard to get your voice heard when you have to talk to the CTO to get a whisper in to the CIO, to then get a murmur that may not be understood by the CFO, to maybe get one bullet point or asterisk point in a board level meeting at some point. So companies just aren't ready for this in many cases. And this also discourages CISOs from having meetings directly with the CEO and the board. N minus 4 in many cases, is people who are managers or low-level directors. And, they're not expected to just go straight up to the CEO and say hi and tell them about their concerns. That's generally not what you expect. You expect maybe 1 or 2 levels below the CEO to be able to have that kind of a relationship. But so many times in the company, really it just seems they made some IT manager the CISO, and that's it. And it shows. And it shows in the way they report as well, or the way they don't report. And, some companies even worse think not knowing is better. Knowing nothing is better, because if the CISO doesn't say it or I don't hear it from the CISO, then, I'm not responsible for it. And that's what has led to some people kind of quipping that, we're scapegoats. Well, that's on you. You need to define that relationship in your company. And this has to change, right? CISOs need to start changing the nature of the role of their organizations. And one simple way of doing it, and one thing that you should really be thinking about as a result of this Wells notice, is: are you covered by your organization's E&O insurance and directors and officers insurance? Because you really should be. The CISO has to sign a lot of documents around risk acceptance, quarterly reports to the board, publicly traded companies. This is where the SEC comes in. You have to make statements as a CISO to the SEC and government entities under penalty of perjury, under penalty of law, so on and so forth. That's a lot of burden not to be covered by your company's insurance, errors and omissions, directors and officers insurance. And if you aren't covered specifically by the company's insurance policy, well, then that means they have to spend money to protect you and their firm. So really, it's mutually beneficial that you get on that insurance, because when you represent that level of exposure to a company, they need to take the appropriate measures to protect themselves and the company as a whole. And really having this conversation allows you to begin outlining what your role is, what should it be, and how you want to develop in the organization. When you think about, your chief legal counsel usually isn't buried under 4 or 5 levels of roles. Even if your chief legal counsel reports up through someone else, the chief legal counsel usually has a seat at the executive leadership team to provide that privileged communication. That we're in here with our lawyer, and this is a discussion with our lawyer about what we can and can't do, or should and shouldn't do. And so there's the ability for the lawyer to protect you with those provisions in the law that allow for such things. But it's also there, your lawyer's there at the table with the CEO and direct reports to cover those liabilities, to talk about, what they need to do, their proper processes, where those risks are. And that's just from a legal perspective. You really need to have because of the realm of IT, the way in which your technology really does reach into all of everybody's lives, you need to have your CISO at the table these days, at least on a regular basis, to directly report those things to them. And having that conversation with your lawyer actually is a really good thing. Talk to your chief general counsel, talk to them about cybersecurity, talk to them about why it's important that they actually retain some outside counsel that has cybersecurity expertise. And maybe you go to your cyber insurance to try and get some of that guidance. But you really try to get that, and you maybe even try to get someone who can advise you from time to time on, how to make sure you're doing things correctly, so that you protect the company and yourself. But at the end of the day, the errors and omissions insurance, as well as your company's lawyers, are there to protect the company first, not necessarily you. If it means taking the company down or taking you down, they will take you down. That's just the harsh reality of what it is. So the real question is do you have a lawyer for you? At the end of the day, since the company's going to protect itself, you need to protect yourself too. You have to balance the two. And so you really need to think about, not only do I have errors and omissions insurance coverage, but do I have a lawyer I can talk to personally to talk about my role, to talk about filing requirements that are out there, to talk about ways in which I can take notes that I'm entitled to take and that will hold up in court if anybody ever points the finger at me saying you never said this, or you told me this but I didn't listen, or whatever. How do you take notes in such a way? How do you retain that knowledge in a way that it's going to be respected in court, so that you can protect yourself at the end of the day if someone tries to make you that scapegoat and throw you under the bus? Regulation in the future of InfoSec, though, really is really what we're talking about here, I think, because this and many other actions from government are really showing the appetite government is beginning to have for regulation. President Biden has, essentially a whole plan out about cybersecurity for the country, and labeling a lot of things that we've not previously thought of as critical infrastructure as being critical infrastructure. Governments are beginning to see how interconnected systems are, not just with other systems, but with vital services, products, infrastructure, and how easy it is, honestly, for attackers to knock those systems down. You could think of the Colonial Pipeline, for instance, and how much companies feel incentivized to treat security of their systems as a cost center to be minimized. I believe more regulation is going to come and might include strengthening the role of the CISO to how GDPR created a DPO whose first interest is to data subjects within the bounds of regulation versus the stock price of the company. But when it comes to SolarWinds, when it comes to the CISO, what do I think is going on here? Well, I'll tell you. I think the SolarWinds Wells notice likely outlines concerns the SEC has with statements made by the CISO to the SEC and stockholders that didn't quite add up when they investigated after the breach. And I think it's possible that the CISO maybe painted too rosy of a picture, was too general so as to gloss over, certain things that people should have been aware of. And that's what I would imagine is kind of like at least the lowest bar the SEC has to clear to send out a Wells notice. Now, it could be far worse. It could be that the CISO did a lot more. The CISO may have known, well that, risk A, B, and C exist, but minimized it beyond what you could just kind of say is professional opinion, minimized or even denied the risk or didn't report it or hid it from people for whatever reason, and ultimately hid it possibly from the SEC and stockholders. And they've uncovered that in the middle of the investigation and are going to hold this person accountable. That's possible. But I think at the very least, there's incongruency between what they found in their investigation and the statements they'd been making for years. Across the CISOs, there was a CISO before this one. This one was there before the breach and during it and after it. So makes sense that this person should be aware of certain things and should have reported on certain things, and maybe he didn't. But at the end of the day, too, the SEC could be going too far, could be stretching facts beyond what they really should be, and maybe are purposefully being obtuse with regards to certain things that one has to do in information security and in business, and is going too far and stretching really the reality of what's going on. So that could happen, too. But I am going to leave you with this. SolarWinds is claiming that this Wells notice has a chilling effect on companies reporting breaches and incidents. And I think that in and of itself exposes a perverse incentive on the part of SolarWinds, and I think is actually rather disgusting and exposes them for what they really think their role is in our community and in our organizations. Because we definitely want companies to report issues and be open with their stakeholders. But if the SEC is correct about what they're reporting or what they're giving notice to, SolarWinds likely wasn't as open as honest as they should have been. So if anything, these actions should make an example of those who try to hide or cover risks. It's actually their duty to report. Of course, that's if the SEC is correct. So what are your thoughts? Do you think everyone should be worried and running for the hills now? Do you think the role of CISO is getting more stressful? Do you feel empowered by these moves? Do you feel chilled by these moves? If you're someone who's wanting to be a CISO, what does this mean to you? Do you think the Wells notice is complete BS and is just, the government trying to shake someone down? What are your thoughts? Leave them down in the comments. Catch me on social media, and I'm going to catch you in the next one.